Dr. Tladi, your mic is not on.
I thought it was on, but anyway, sorry about that. Afternoon, everyone. Oh, it's still morning. Morning, everyone. I'd just like to thank Prof. Snail for the invite and his team, and also to have Ms. Machobane working together on this today. I'm not going to take most of your time because I see time is already out. I'm basking at the sun, so bear with me on this one. Let me just try to upload the slides that I have, being an academic that I am, although bulky, but I do hope that they will at least outline some of the things that are happening. Let me know if you see the slides on your side. Do you see the slides? Are the slides visible on your side?
No, they're not visible yet, Doctor.
Not yet, okay.
No.
Okay, while we are waiting for the slides, I might as well move on. Parts of the presentation that I'm doing today, which is really an update, I've already presented at the conference some of the parts, but I'll just outline what the updates are. And it's so exciting to be in a time that we are in, that for the past 2 decades, people have been asking for these kind of legislations to be in place. While it is good and they are a step forward, it also comes at a time when there are also other challenges, new technological technologies that are also affecting these arenas. So my slides then will be, my outline will be my background in South Africa Cybercrime Regulatory Timeline, South African Cybercrimes Act 2020, the way forward, and perhaps a conclusion. The background really is mainly the stats, and I must say most of the speakers before me were highlighting some of these things. We all know that today the Africa Forum is also, there's an event taking place, Africa Forum, together with the COE, fleshing out cybercrime in Africa and trying to also build capacity in these instances. So really looking at the cybercrime space, Shruti says that cybercrime is described as a transitional crime, which has a global implication on the political and economic nature of a nation, with real-time communications and the pace of its processes undermining the power of state control or even protection of both markets and populations from external forces. Mimecast last year during COVID, they released a report saying that cybercrime had increased by 33%, and you can see the types of crimes that were taking place or that have increased during the time on that slide. Then the second one, they also said that we know, I think we have 60 million citizens in the country, and most of us, the penetration here is 80%. It can be even more, considering that we are in the COVID pandemic era, whereby everyone now is forced to work on offline. So we heard yesterday the president saying that now we are in adjusted level 4. Then that means that most of us now are still back at home, and we are not, our movements are limited. We look at the cybercrime again, 86% of South Africans who use online banking. Again, that might have increased, but the sectors that are predominantly actively affected by this will be your banking, financial institutions, the governments, e-commerce platforms, mobile payments, and telecommunications, and the list goes on. The types of cyber attacks that we have heard, I mean, perhaps around about the 2019, but they were there before. This doesn't say that they were not there. They were always there, but we have seen an increase again with the denial of service attacks on SA banks and customers not being able to access their details online or to transact. We've also seen with the city of Joburg and the others. I'm sure this year it has increased as well. Then we have scams and all the other, and phishing as usual. We've always had that one. Going into quickly the South African Cybercrime Regulatory Timeline. We hear, there's a description that we get usually when you come to the regulatory issues regarding cybercrime in South Africa, is that is lagging behind. It remains lax, that South African businesses are underplaying the danger of cybercrime, and then that most cases go unreported. And then we find out also that the third, South Africa would be the third on the list of cybercrime haven in the world.
Dr. Tladi?
So, hello?
Are you still not able to share your slides?
My slides, let me just try again. Upload. The error is active, but it's not uploading, so I'm not really sure what what the problem is.
Okay, so for the participants, may we please continue without the slides, and we will try and see how we can make them available at the end, so that Dr. Tladi doesn't lose her trail of thought. Please, if you'll just indulge us. Thank you.
Thanks. So now going back to that regulatory frameworks before, or just going down memory lane, we see that even before the Act came into being, this started with the issue paper by the South African Law Commission on Computer-Related Crimes in 1998, where 6 objectives were covered, both of substantive and procedural provisions, which we later see in the bills that came out, including the Act now. And then we see the ACTA, Electronic Communications and Transactions Act 24 of 2002, Chapter 8 has contained cybercrime provisions, and we know that in section 85, of course, it gave provided definitions of access and other definitions. Then 86, 87, 88, 89, then there was unauthorized access, computer-related extortion, aiding and abetting, and penalties. Then came the 2015 draft bill, which had both cybersecurity and cybercrime provisions. And the criticism was that the cybersecurity part was giving the government extensive powers, including right to freedom of expression in section 16 of the Constitution. And those we know later on, those provisions were taken out, were removed from that bill. Then the 2017 bill, when it came out, it was just cybercrimes, listing of cybercrimes. And on the 1st of July 2020, the National Council of Provinces passed the bill, and then the President signed the bill into law on the 26th of May, as we have heard this year. And the short title then of the Act in Section 60 is the Cybercrimes Act of 2020. This Act will come into action on the date by the President by proclamation in the Gazette. And also different dates may be fixed in respect of different provisions of the Act. Now moving on to the Act itself, the preamble is very long. I'm just gonna list some provisions in the preamble is to create offenses which have a bearing on cybercrime. We'll see that in Chapter 2, it criminalizes the disclosure of data messages which are harmful and to provide for interim protection orders, to regulate jurisdiction in respect of cybercrimes, to further regulate the powers of investigation of cybercrimes, to provide for an establishment of a designated point of contact, and to further provide for the proof of certain facts by affidavit. And it also provides for capacity building. All these provisions or list here it's found in the sections that come after that. So let's look at Chapter 2 in passing. It's just an overview since it's an informal discussion. I know most legal practitioners are in, we can engage afterwards, and I'm also looking forward to hearing what you are gonna say about this. But Chapter 2 now says it's the title is Cybercrimes, Malicious Communications, Sentencing and Orders to Protect Complaints from Harmful Effect of Malicious Communications. So Part 1 then outlines what the list of cybercrimes that are out there. First one, unlawful access. Anyone who accesses a secured system, then in a way to alter whatever that is there or modify or delete will be found guilty of that offense. Then you have unlawful interception. The Act does define what interception is. And interception is acquisition, viewing, capturing, or copying of data. Unlawful acts in respect of software and toolware, and then hardware tools. Unlawful interference with the data computer program. We see unlawful acquisition, possessions, provisions, receipt of passwords. All these are in Chapter 2. And then we see the cyber fraud, cyber forgery and uttery, and cyber extortion. These are the provisions that were first outlined in the ACTA, which also made sure that the common law crimes also can be dealt with. Moving along, then you have Part 2, malicious communications. Then the communications here that are covered are those that incite damage to property or violence, those that threaten a persons with damage to property or violence. And also you have a disclosure of data message of intimate images in Section 16. Then you have issues on abetting, attempting, conspiring, aiding, including inciting, instigating, and procuring to commit offense. All these are in the Act itself. the 2020 Act. So what I've realized is that the Act has they've made just minor amendments or adjustments either to the structure or to the wording of the provisions themselves. For instance, the disclosure of data, message, or of intimate image, it used to be distribution. Now it's the disclosure of that, and the provisions are in the Act. Then moving along, penalties, then we find in Section 23 of the Act. And then jurisdiction of cause, we find also in Chapter 3 and Chapter 4 is powers to investigate, search and access. Then we've got the issue of mutual assistance, whereby the country will be liaising with other, having mutual, how can I put it? Whatever, looking into other foreign nations to cooperate with them and collaborate with them on issues of cybercrime. And that section also outlines how that should be done. You know, that you will be requesting assistance and cooperation with another country, and also that the information must be spontaneous information, and also that those countries must inform either a country, or we must inform that other country of the outcome of the request for mutual assistance and expedited disclosure of traffic data. And also to issue direction and requesting mutual assistance from those states. That will be in Chapter 5. Then you've got Chapter 6, which is a designated point of contact. Whoever is affected, then they can, the Act outlines processes in which to go about doing that. The subs being one of those places that are designated to work with the people on that you can go and to the subs and include lodge a complaint, and that point of contact in section 52, then it says that the subs also must be equipped to do those things. And I think there's a bone of contention even before this Act came into being, that are they equipped? And this is what we've been hearing. This are the organizations, you know, are the stakeholders themselves equipped to deal with these kind of issues? Do they have the necessary skills? Then we see issues of evidence, reporting, and obligations and capacity building in sections 54 to 56. And yeah, then section 60 already talks to the fact that we will know that the president will give they will clarify as to the date of commencement. Just going into perhaps maybe the way forward to sum up what this Act entails and what it has, and what are the challenges moving forward, is that it has created the Act. It created new offenses that are related to data, to messages, computers, networks. You have those, the hacking, the unlawful interception, ransomware, cyber forgery, and uttering cyber extortion. And the list goes on in Chapter 2 of what this Act has really, the offenses that have been created by the Act. What we see is that there are some lack of definitions here or there. For instance, no one defines what cybercrime is, and we all know that there's no universal definition for cybercrime, but we go by that definition that if those crimes that happen, you know, using either a computer, the computer is a tool or an object, or, you know, they are used via the internet. Hence, we see all these different terms in different legislative provisions of other countries. Others will say this in information communication technology crime, it's an internet crime, it's a cybercrime, and all those. But South Africa is sticking with cybercrime. Now, the issue of the subs. These are either members or the investigators. They are given extensive powers to investigate, search, access, and seize computer, database, or networks whenever it might be located, provided they have a warrant. Then you have, again, a role player national prosecuting authority. They will keep the stats on the number of prosecutions for the crime. And then you'll have also the Minister of Police, who must establish, as I've noted earlier, the point of contact by cybercrimes and the capacity to detect, prevent, and investigate cybercrimes. The biggest challenge now here is one, lack of skills. And this lack of skills, we're looking at the subs. Are they equipped to deal with these? Are the systems in place? It's the questions that we've been hearing in this webinar. Are the systems in place to help the subs to perform their duties, especially when it relates to cybercrimes? The other challenge that is out there is also legal practitioners that are out there who will be dealing with these issues. Whether the members of the the bench. Are they equipped to deal with these issues? Are they skilled, in ICT matters and stuff? And we now know that even though we've been talking about cyber law or ICT laws for the past 2 decades, the reality has hit now that there's no turning back with the COVID and whatever that is coming, the new technologies, whether it be AI or Internet of Things, that are also going to challenge the provisions of this act, and also the POPIA, as we had heard earlier on. The issue of education and awareness remains a contention. For me, getting the final act in 2 languages, it's also problematic, because you want people to know about what is happening here. But if it's just in 2 languages and then 9 languages are left out, we still need to work on that. And our education then here and awareness, it will also be relating to the savviness of the people to use these means of, the gadgets that we're using now. Before COVID, we knew that people have access to the internet in cities, but the outskirts or the villages and stuff, they just don't have those amenities. They just don't have access to that infrastructure. The question then is the infrastructure, are the systems secured, as we have also heard earlier on? Are they secured? What is it that is being done in that regard? So the new technologies I've already highlighted. I know there's a conference coming up which will deal with the AIs, and when the computers now learn, machine learning takes place. The biggest question then will be, who's committing the crime? Is it the computer? Is it the software producer? It's all those kind of things. And thinking of this presentation, I couldn't help but think of the movies that are out there already, whether it's iRobot, it's AI, all those, the automatas, way before we came into this space, those were out there, those movies were out there. Now they're challenging the way we are doing things. So I think I'll just end there, and I'm looking forward to the engagement. I might not have all the answers that Anastasia raised or other people are gonna raise, but I'm really looking forward to the engagement, and I'm always excited to exchange ideas with those that are in practice, because as academics, most of the time we're in our own silos and we're writing. So I really appreciate this space, Prof. Snail, and I appreciate the listeners for listening. Thanks.
Thank you so much, Dr. Tladi. I just have one question. I know I threw a lot of questions at the beginning, just to get the conversation, directed in a certain manner. But which sections, or rather which other legislation is actually impacted by this Cybercrimes Act?
Okay, there's a list of schedules in the Act itself, and the first one will be your cybercrime provisions in the ECT Act will be deleted, which is the Chapter 8. And then Section 89 in that section, in that legislation, then will be altered. But that is one of the Act that is being provisions in Acts that is being affected. Then you also have the Regulation of Interception Communication Act. The list is long, but it is long. But the first ones are those 2, the original ones in the ECT.
No, thanks very much. I mean, you touched on the important ones, which I just wanted to highlight. That whenever there's legislation, we tend to only look at the one, but then there actually is a knock-on effect on other pieces of legislation. For example, even with the POPIA, it impacts other legislation, both indirectly and directly. And that's why when, as legal advisors, as lawyers, we give advice, we need to always be cognizant of the fact that we should not only look at one piece of legislation, but also cross-reference and see what else is being impacted. I'm glad to see that we're actually keeping to time. Prof, do you want to just come in there and just give us your wearing your lawyer's hat? Just share your views with us on the discussion that has been held. Yeah, so I've already made the disclaimer on your behalf. So wearing your Snail attorney's hat, just tell us what you thought of the discussions and what you'd like to add.
Thank you, Ms. Machobane. I think once again, it shows that you don't have to blow your own trumpet to communicate things to people. It's always a pleasure to collaborate with colleagues who are knowledgeable in their own right and who can communicate some of these things which maybe I can't communicate due to the limitations of being at the regulator. But with that having been said, I mean, the POPIA is going to be here forever. You know, we need to understand this law, and I think compliance with the POPIA is key. I mean, the 1st of July is just around the corner, and you know, for those of you who don't know what the POPIA is, I hope today was an eye-opener. You know, colleagues are here, Advocate Krunye is here, Ms. Machobane is here, Dr. Tladi is here. If you need help, if you need advice, please do shout at these legal professionals. They do know what they're doing. It's almost, you know, very, very good to see that the whole impetus of the POPIA has finally gotten into people. Regarding the cybercrime, it's always very beautiful listening to someone else talk about the Cybercrimes Act. Advocate Krunye and I were very busy, you know, advising. We were on the Ministerial Advisory Committee, drafting the various different bills, and, you know, to see the final bill in its current state is really beautiful. You know, one must congratulate and for having a piece of legislation that is long outstanding. I mean, the ECT Act came out in 2002. We are now in 2021. So, you know, I'm quite happy, like Advocate Krunye mentioned, a country like Zambia, they drafted all three immediately: the cybercrimes bill, the data protection, the PIA. So, you know, I think we are at the right space right now, and I don't want to spoil it. I actually enjoy sitting back and listening to other people as well sometimes. So I'm going to give over to my lovely colleague, Ms. Machobane, to give us a closing message and a vote of thanks. Thank you.
Thank you. Thank you so much, Prof. And it was really a pleasure to give you a break and just let you, you know, just enjoy listening to us, you know, taking this topic forward. There are quite a lot of questions still in the chat box. I know we had said that the format would be that we will be answering some of these questions. What we will do is we do have your registration details, and in order to respect time, you can keep popping them in the chat box, and we will then endeavor to come back to you. We did actually note that there is not sufficient time, you know, to take some of the questions, but I see my colleagues are saying we must try and take a few questions. If you'll indulge us, then at least until about 20 past, it's now 12:15, then we can quickly just try and take a few of the questions so that we cover as many as possible. But fear not, whatever we haven't covered, we will definitely pop it in an email for you. There's one question here from Advocate Nandi. It says the boundary management issues on the role players POPIA versus cybercrime implementation in the space remains critical. I think that's actually a comment. And then there's a question from Nehlohonolo saying, is there an onus on the consumer to prove there was a breach of their private information? Prof, do you want to take that one? Prof or Dr. Tladi or an advocate, can you please take that question? May I repeat the question? Is there an onus on the consumer to prove there was a breach of their private information?
Oh, it's a POPIA question. Okay, I'll answer that. Yes, in terms of Section 22 of the POPIA, there is a duty to report to the data subject, and there's a duty to self-report to the information regulator. And a data breach it's not a quantitative exercise, sorry, it's a qualitative exercise. So if you've lost one email address or one document, that is a breach that is reportable, unless there's a criminal investigation that may be compromised. Then you can delay the notification. But save for that, all breaches are reportable. Thank you. Sorry, my microphone was a bit sticky there.
Don't worry about it. Lishwanal again is asking, like in the case of a public announcement, in the case of Experian breach on the banking sector last year, do you then have to prove yourself that you were a victim if experienced fraud on your account and the bank refuses to acknowledge? Prof?
Okay, regarding Experian, that's quite interesting. I can answer that. There actually is a report that's been finalized by the regulator, although it's not out yet. But once again, you know, even with the Experian data breach, from what we know from the public, we know that there was a perpetrator and that perpetrator was identified. If you look at 23, what it says on how the notification must be done, you know, they went to the media, they told us that it was this perpetrator, a criminal guy who did a criminal misrepresentation, and this was the effect thereof. So it is always very important to notify the data subjects, so that the intention of notifying the data subjects is to ensure that they are vigilant. I mean, we can't protect our personal information, you know, 100%, but at least if you know that your personal information in the form of an account number or ID or something has been breached, then if you see someone doing a credit check or you see suspicious transactions, you will at least then be vigilant. I think that is the whole idea behind data subject notification, to make the individuals vigilant so that they don't suffer more than they've already suffered.
Thank you so much for answering that question, Prof. I'm just trying to scan through. Togo is asking, what is the effect of non-availability of cybercrime laws in neighboring states on the mutual legal assistance issues? Advocate, can I please ask you to answer that one?
Anastasia, I think Advocate had to excuse himself, so I'll answer that one.
Can I give that on to
Yes, you can, Mr. Gumede.
Okay, thank you. I'm just going to keep my my video off, and thank you, Prof. Thank you, Ms. Machobane. You know, even with the Protection of Personal Information Act, there are these concerns of trans-border flows of information. So if you look at, for example, let me just see if I can quickly find the section on trans-border flows. While I'm looking for that, yeah, while I'm looking for that, I believe it's Chapter 9, and it's contained in Section 72 of the Protection of Personal Information Act. So it states just the first opening line is, a responsible party in the Republic may not transfer personal information about a data subject to a third party who is in a foreign country unless, and then if I may just sum up what that basically states, is that there should be, you know, laws, basically going back to Togo's question, there should be laws that are sort of, you know, equivalent to the POPIA in this case. But to answer the question specifically, it definitely makes it difficult, you know, for issues of mutual legal assistance where cybercrime protection laws are not in place. But at the same time, if you look at, for example, the SADC region, South Africa is a country that subscribes to the Roman Dutch common law, the English law. You go to Zimbabwe, you go to Eswatini, you go to Botswana, you go to Lesotho, you sort of find the same situation. And the beautiful thing about that is that we already have in the in SADC, just SADC by itself, we've got some model laws. We've got a model law on data protection. And then there's also, you know, a cybercrime model law. And then also in the AU, we've also got some conventions there. So I believe that there's sort of a fallback position in terms of how countries can assist one another. You know, obviously terminology being different depending, you know, I know, for example, the country of my birth, Eswatini, you find that the terminology such as, you know, what a data controller is, or what a responsible party is in South Africa, the terminology is different there. But we've got these conventions, and I think it would just be an issue of sort of, from an application perspective, applying one's mind if there is actually a need for law enforcement to, you know, assist one another in terms of curtailing cybercrime in those aspects. So I believe that, considering that South Africa has the Cybercrimes Act, which is now, you know, has been passed into law, and they are also developing cybercrime legislation in different jurisdictions, for example, around Africa. It's not like there's no hope. I believe I've answered that question to the best of my ability, and I'm obviously at the hands of, you know, both Ms. Machobane and Professor Snail, if there's any further elaboration on that.
I think you actually have covered it sufficiently, and also I don't know if Professor Snail wants to just add anything. However, but you have given sufficient context, and I'm going to take one last question from Advocate Nandi. She's asking, Prof, what is the impact of the Canadian case on the reporting of breach if there are several providers in the value chain? Prof?
Right. I would assume you are referring to the new Canadian case and where Equifax's fine was reduced due to, you know, the ability to prove damages. And because, like you said, there was a value chain. Look, I think responsible parties, or data controllers as they are called in Europe and in the rest of the world, need to understand that the buck starts with them and it ends with them. So, you know, you may have operators that you're using that are third-party service providers in terms of, you know, processing data for you. We have the South African locus classicus of Black Sash versus SASA, where SASA was deemed also to be liable for the personal information abuses that had been done by the service provider, Net1 and CPS. So I think responsible parties must understand that wherever the breach happens, in terms of the third parties that you are working with, if you are the entry point, if you are the responsible party, you will be liable in the event of a breach. I hope that gives clarity. Advocate.
Thank you. Thank you so much, Prof, and thank you so much for the attendees. You've really indulged us in terms of your giving us your time. And to the panel, we've had fun getting ready for this discussion. I do hope that there will be more panel discussions such as this scheduled. As I said, this is the second one that we've had. The only difference is adding, we've now had Mr. Gumede and Advocate Grenier as well on the panel, and I'm looking forward to continue working with them, because as the developments happen, you know, we get together and we see how we can actually share this information. And as Prof has said, you know, we are here to assist you with information and also for clients who need assistance in this area, you know, to know where to reach out, and also to create this, you know, community of experts in this space. So we look forward to sending information on our next webinar. And in terms of closing remarks and just thoughts, yes, there is a lot happening. There is a lot happening on the continent as well. You will note that even in Nigeria, they are actually also quite progressed in terms of their data privacy laws as well. They have their own NGDPR that they have implemented. Prof has spoken quite a lot about the conventions in the past. So as a continent, we are on the right track, because if we want to be trading internationally, we need to at least meet, you know, I think the minimum criteria. and also be able to cross those bright lights, as we say in competition law. So we are on the right track. It's just a matter of making sure that implementation will happen. There are some concerns insofar as the Cybercrimes Act is and how ready we are to actually implement. I know I tried to put Dr. Tladi on the spot there by asking her, but it will depend on the readiness so that the effectiveness of the legislation can also be tested. And with that, I'd like to hand over to Prof to just close. And yeah, and from me, it's goodbye. And you'll see that we are hosting another webinar on Thursday, different to this one. We'd love you to join us. We will be talking about skills development and mentorship. It's about creating employment. These are 4 amazing panelists that will be talking about the work they're doing in terms of skills development, skills transfer, and how mentorship fits into that. Prof, can I give you the last word, and then we will close. And to all of you, I say, have a beautiful week. May God bless you. Namaste. Prof?
Yes. From my side, thank you very much. Bye, Danki, Raleboa, Siabulela, Totsins, second half.
Bye, everyone.